Hello, my name's Wayne Middleton. I'm the Global Vice President for Risk for Momentus Technologies. And today I'd like to take a lawyer's perspective on the important issues around risk assessment and incident management in public venues and events. And in a second, my good friend and colleague from the Academy of Venue Safety and Security through IAVM, Joey Sampson, is going to join me. Joey's a lawyer. He's a partner actually at McCaffin Law Firm in Dallas. And we're really looking forward to the conversation and for him to share his expertise. Before we start though, like all good conversations that are out in the public talking about points of law, I'm going to start with the disclaimer, just that anything that constitutes any comments around legal points of law, please go away and check it with your own legal professionals. This doesn't constitute legal advice. Joey, welcome. How are you?
Thanks, Wayne. I'm good. Thanks for the invite.
Terrific. Look, let's get into it. So just perhaps we can start by you telling us a little bit about yourself and your legal expertise.
Yeah, my name is, as Wayne mentioned, Joey Sampson. I'm at the firm McCaffin Shakui Evans in Dallas, Texas. My office, our original office is in Dallas, Texas. We've got 4 offices now that spread from Dallas, Frisco, Texas, Houston, Texas, and then also Los Angeles, California. I practice civil litigation. I've been an attorney now for 17 plus years, and I've been at this firm for all of that career. We've touched on a lot of representation of venues, especially dealing with the Cowboys organization, the Dallas Cowboys, American football here in Dallas, Texas. And so that's kind of a background. I've kind of run a broad spectrum of civil litigation from personal injury, both on the defense and the plaintiff side, and then insurance coverage work. So I've done quite a bit of different aspects in the civil litigation world here in the U.S.
Thanks, Joey. Look, in some of the sessions that we've done previously, we talk about the drivers of why people need to take risk management as a serious issue as venue operators. And obviously, the litigious nature of the United States is probably a good point to start with in terms of liability and negligence. Why are those so important for venue managers to take seriously? And what are some of the elements of that they need to understand?
Yeah, I guess we can kind of just start about what is liability here in the U.S. and in Texas and all throughout the 50 states. Liability is obviously the state of being responsible for something, especially by law. It's tort law here in the U.S. and that tort comes from a French word which twisted or a wrong, and it's a civil wrong from which injury occurs to another and from which a remedy may be obtained. And so why is that important to venues? It's important because obviously venues can be held liable in situations where they've done a wrong that results in the injuries to patrons or their customers or even sometimes their employees. So I think venues have to really, we're here talking about risk and risk assessments, and I think that's why it's so important for venues to look at that aspect, is because you can be held responsibly, civilly, for wrongs that you've done that result in injuries to your patrons.
Right. And how does that differ from other countries? I know your focus is largely on the US, but is there any advice you can provide around how that negligence law and the concept of liability varies perhaps around the world?
I think if you do an assessment, there's going to be general liability laws in almost every country that you find, throughout Europe, Australia, Canada near us, and they're all going to be relatively similar. There's some, I think, concepts or areas where there could be a presumed negligence, as opposed to the general concept of where negligence law came from, is that you have to prove as a plaintiff, you have to prove that you've been wronged. You have to prove that a defendant a venue has done something wrong that resulted in your injury. In some instances, there may be some countries that have a presumed negligence where, going into it, the plaintiff doesn't have to produce the evidence. They have to show that they were injured, and then the defendants have to provide a defense as to, how to exonerate themselves. But for the most part, in most countries, you're going to have like we have in the U.S., where a plaintiff must present evidence to a court at law, whether that be a judge or a jury, like we have here in the U.S., that provides that there's been a violation of the reasonable person or the reasonable business standard, where a person has been injured and they can prove the venue or the defendant's done something wrong. Most countries are going to be similar to that. I think what we're seeing now is that there's actually, say in the UK, you've got the protect duty that's, I think, come from the Manchester Arena event a few years ago. I think it's also known as Martin's Law. To me, that is what we're seeing is a kind of a melding of criminal law overlapping with civil law in many ways, that there could be criminal responsibilities in many countries for things that venues do wrong. If you don't do a proper risk assessment and something occurs, like at the Manchester Arena, that you can also be held criminally responsible.
Right. And I think to take that one step further, in Australia, there's now industrial manslaughter legislation that's being rolled out across the country by each state that's linked to health and safety legislation with fines of up to 20 million Australian dollars for an individual. 20 years of imprisonment and $18 million for fines. So there's a big stick out there, and I think as the legislation and statute evolves, we'll see the stick get bigger.
Absolutely.
Let's talk now about negligence cases and what people can do in relation to risk assessment in particular, because I know that's been brought up time and time again, and as we've both seen in the US in particular, people talk about having done a risk assessment, but there's a level of documentation that doesn't always support that. What can you comment on there?
Yeah, kind of backing up to a little bit more about the duty of care that we have here in the US. In most states, it's going to be very similar. And the duty of care, the requirement that a person act towards the public with the watchfulness, attention, caution, and prudence that a reasonable person or business would in the same or similar circumstances. If a person or a business's actions don't meet that standard of care, then their acts are considered negligent. Any damages, if their acts are negligent and there's resulting damages to a person or sometimes to property, any damages resulting may be claimed in a lawsuit for negligence. And so when we break that down, what we have to prove here, if you're a plaintiff in the U.S., you've got to prove first that there is a duty. Almost always there's going to be a duty for venue to their patrons, correct? And then so that's the defendant's duty that's owed to a plaintiff. And then you have to have a breach of that duty, and that breach has to result in an injury, and the injury has to actually be proximately caused. That's the term of art here, proximately caused by what the defendant did. And part of that proximate cause part is foreseeability. So that foreseeability is what really, I think, takes us into the risk assessment portion, right? Where are we vulnerable? That foreseeability is a huge component. I think that is what's argued about a lot in these cases at most times. It's, I know I've heard you talk about it, Wayne. It's where are we vulnerable as a venue? What are our risks? And so I can just tell you in cases that I've been a part of, I'm in a part of now, that the risk assessment is a highly litigated area when something goes wrong at a venue. There's talks from experts. There's talks to multiple defendants in cases about, okay, how was a risk assessment performed? And if not, if you don't have something in writing that proves it was performed, why not? that becomes a very highly contentious area in our litigation when we're dealing with venues. And I think, that's how it all ties into this duty of care and how you properly present that you have met that minimum standard that we always talk about. What is that minimum standard, that we can meet to avoid liability? And I think that begins, in the cases I've been a part of, at least, that begins with, was there a proper risk assessment performed?
Right. And the risk assessment really is the start of the process, right? It's understanding the contextual elements of whatever the event is that you're planning, and then digging into that to understand what is foreseeable in terms of things that can go wrong. And I think as an industry, as venue professionals, we all know largely some of the things that we need to be dealing with. We know about counterterrorism, we know about severe weather, we know about trip and falls, we know about crowd management. And there's many other elements that are unique to some events, and that's why it can't just be a template, right? It needs to start with a template perhaps, or some sort of series of known risks, but then asking yourself, what is it that's different this time around? And learning from the mistakes of others, and being able to then feed that back into the system, and then understand again post event, looking at whatever data that's been collected from that, and feeding that back into the system. And that again, from a legal perspective, helps understand what is foreseeable that needs to be addressed. That's probably a good segue actually into incident management. And I just want to get your views then on the value of reporting incidents and documenting those incidents, and then feeding that back into the risk assessment.
Yeah, I think one thing that needs to be done is incident reports, incident reporting, an assessment. You just mentioned that how you can learn from others. Obviously, I think that's important internally, how we learn from our prior events and our prior incidents that occur at our venues. I think that's a big deal. I think it always needs to stick to the facts. At what actually happens. We can use surveillance video, firsthand accounts. I never want to see incident reports that have opinions written all over them. But I think incident reports and a review of those incident reports internally by higher ups, and then trickling down to how do we use those incident reports to deal with and communicate to our staff. Look, this is what's happened to us three times in the past. How do we avoid that? Getting feedback from your staff. How do they think you can avoid that? I think incident reporting is a big component of how do we properly assess our future risks. Our vulnerabilities. It's been proven that we're vulnerable in these ways. That again goes back to foreseeability. If 14 other venues that are similar to yours in the United States when we're dealing with it, or let's say in Texas, 14 other similar venues have dealt with this specific incident, and yet you've done nothing to assess that risk at your own venue, and then it occurs to you. To me, that's an automatic ding against you by a jury or a judge when they're making the decision. How could we have avoided this? Well, it happened to 14 other venues in your state, in your local community. Why were you not aware of that? And if you were aware, why didn't you do an assessment to figure out how you can prevent that properly?
Right.
And I think that's a huge component, is using incident reports to help that.
Right. You bring up a really good point there. There are, I guess, two elements to that foreseeability, right? There's the incidents that are occurring at your venue, but there's the incidents that are occurring at other venues which won't be in your incident management system. But you need to be bringing, and shown to be bringing, those two things together in terms of the chance of it occurring, or the likelihood, if you like, and how bad can it get, and then using that as a prioritized list to come up with reasonably practicable action plans for dealing with it, both on the prevention side and the preparedness side. What can you talk about now in terms of things that venues can do on a practical level around things like training and using technology and response planning and so on?
Yeah, I mean, I think with the way technology is advancing, I think it's going to be a big part of how we make these assessments, and I think it. To go back to what I said earlier, how do we use incident reports? Well, you've got to involve your staff. How do you use those in involving your staff? It goes back to training. You've got to, I'm no expert on the training aspect. Unfortunately, most times when I'm called, it's when an incident's already occurred, and I've got to now come in and defend the company. Too often, I think we don't have the foresight to, how do we hire people? Not me, but experts say like you, and folks, with that have the technology out there. Whether it be Momentus or others that have technology that can assess and help us assess and partner with us in assessing these risks. But where does it go back to? It goes back to, how do we use this data? Let's start with training, right? We've got to have proper training. We've got to have, I think, we hear about tabletop exercises a lot, kind of in the industry, but they're not. It's a word that's used a lot, but I don't think. You don't see them that much when you go back when I'm defending a case and we start talking about this. Okay, well, how did the training occur? That's the questions that we go through. What type of training do you have? What type of written assessment have you done, or what kind of written training guides can you show us that you've gone through? Do we have everybody in the organization, in this department where this incident occurred? Do we have them all logged on or logged off on training? A good example, just a quick example of that is our dram shop laws in Texas, our alcohol sales responsibility. You get certain defenses by ensuring that everybody on your staff has gone through the proper alcohol sales training. And so when and it's like that in other states too here in the U.S., but whenever you can show that everybody has gone through certain training, it actually gives you a defense that makes the plaintiff's burden much higher and much harder to prove, and it makes the case much harder to prove in a dram shop law where they're saying, well, you overserved or oversold us, when the bar or the venue can prove that everybody's gone through this alcohol sales training. That's a quick example, but that can come up in any aspect of a lawsuit. In training is, have we done training on this area where this incident occurred? Slip and falls, have we trained everyone how to properly set up, as simple as a caution sign that we see when we walk through a venue or a mall? As simple as have we trained people how to set that up properly, maybe to cone off an area, as simple as cleaning up spills so that we have less slips and falls and injuries. Simple things like that. Have we gone through training that tells everyone how to treat these things that can occur at our venues? And how do we know those things that can occur at our venues? It goes back to the risk assessment and looking at the hazards and the threats that we face so that we can properly train our staff on how to deal with those.
Right. And I think ultimately you overlay the challenges of, casual workers. You've got staffing issues, which has affected the industry globally now for several years, and ensuring that, hand on your heart, you can stand up in a court and defend yourself, that you're in a state of readiness, not that you just conducted the training, but people were ready. And I think there's a big difference. Induction, perhaps when you first start you work with a new employer, you train them once, but do people remember that, and do they reinforce it, and can you prove it? And I think venue managers are risk managers to a certain extent, and need to constantly ask ourselves, are we in a position to defend ourselves legally? Have we done enough? And to continually asking ourselves, where are the gaps, checking the staff, doing audits, making sure that we can verify and assure that the plans that we had in place are working.
Absolutely. I think the way and the way you prove that here is with documentation. I think that's a huge component of it, is that we document. It goes back to that example of the alcohol sales. If you have to have that documented, you have to have everybody shown that they have the certificate of completion, and so just with different levels of training. I think you got to document that your folks are going through this training, that you have that in place, because I can tell you from experience, when we go into a lawsuit, it doesn't matter if someone says, oh, well, we did an ad hoc risk assessment. Oh, we did training. Okay, can you show me the written evidence? Because that's what we deal with in the court of law is evidence. Can you show me the written evidence that proves that everyone went through this training? Where's this documentation? That's what I'm always asking for. If I was on the plaintiff side, put on the plaintiff hat. That's what the first thing I'm going to ask for. How can you prove that what you said you did? And that goes back to proper documentation throughout the process. Training, retraining, document your tabletop exercises that we went through a event specific plan. Those are the types of things you got to prove is the documentation.
If you didn't write it down, it didn't happen.
Yeah, exactly.
So look, maybe that's all we've got time for. Are there any places people can go to find more help? There's obviously, plenty of websites and plenty of people in every state, but where can people go?
I think one of the things that both of you and I have presented at is Academy of Venue Safety and Security through IAVM. I think that's a point where people can go to and learn more. But I think a starting point is you got to look at your local laws, whether it's by country, by state, by city. Within the U.S., you've got to look at your local laws as a minimum standard, obviously, to meet. But then, there's things that I can tell you have come up in lawsuits through questions of plaintiff attorney to defense attorney. They say, do you know what the Event Safety Alliance is? Do you know what the Event Safety Guide is? And that's been created as, again, a comprehensible minimum standard that, those aren't laws, but it's when we talk about negligence law, we say, have you met the minimum standard? And so when a jury finds that you haven't done that, that means you haven't met even that minimum standard that you've got to meet to protect your patrons. So I can just tell you through lawsuits, questions that come up are the Event Safety Guide, through the Event Safety Alliance here in the U.S., the Purple Guide in the U.K. Through your peers. At what we tell people at AVSS is through your peers that work at similar venues throughout the country. Once you meet and you kind of create these peer groups, bounce ideas off of each other, because that's how you stay abreast of what's happening at other locations. News, like you mentioned, you can Google a lot of stuff these days to find minimum standards. But then you want to partner with outside sources that have the technology that you may not have internally. Something like in partnering or using companies, Momentus, other companies like that, that provide you areas that you may lack, provide you the necessary knowledge where in areas that you may not have the staff to do certain things. But I think there's just so many sources that you could go to, internally, again, going back to your staff, bouncing ideas internally off how do we prevent, how do we meet the minimum standards? You might find the best idea from somebody internally that's seen something and just is too afraid to speak up. By doing these risk assessments, I think you've got to, internally look at your staff. But again, there's so many guides now out there that are written in common language that you and your staff can both understand, that I think you really have no excuse anymore to not be meeting these minimum standards and not be, doing these risk assessments. It's just very important in the litigation world when we're dealing with defending venues. Or on the plaintiff side, when you're going after defendants that have done something wrong, I think that's where you look. Have they met that minimum standard through all these, valuable and easily available resources?
Right. And I think if you're listening to this and you're on an executive leadership team, it's always useful, I think, to understand how that group as a governance entity, what is their liability? What are the systems that can put themselves and their business in the best position to fight those claims, but also to create a safe environment and a great customer experience? So I think that starts with the leadership group. Joey Sampson, that's all we've got time for. Thank you so much. It's been a terrific conversation. I'm so grateful for the opportunity to chat to you as always, and we'll talk to you soon.
Thanks, Wayne. Appreciate it.